This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the tort of negligence and as it applies to construction defect suits, which must be understood by everyone involved in the insurance of people involved in construction. Negligence has the same definition regardless of the state where it is alleged. It has been defined as a legal duty owed to the plaintiff by the defendant, a breach of that duty, an actual injury to the plaintiff, and a showing that the breach was a proximate cause of the injury. This is 1 year of law school in one sentence. A breach of duty exists when it is foreseeable that one's conduct may likely injure the person to whom the duty is owed. The California Supreme Court upheld a judgment for property damage caused by negligent residential construction in a case called Sabella versus Wisler in 1963. The defendant had built a house and offered it for sale to the general public. As it turned out, the defendant's negligent preparation of the lot, in combination with a subcontractor's careless plumbing work, later caused leaks, subsidence, and damage to the house. The purchasers sued for negligence, the builder arguing unsuccessfully against the imposition of tort liability, held that the liability of a contractor should be determined by the consideration and weighing of the various factors bearing upon liability. It was held that the builder was responsible for the ensuing loss. The Nevada Supreme Court, in answer to a question posed by a federal district court, concluded that in a commercial property construction defect action in which the plaintiff sought to recover purely economic losses through negligence-based claims, the economic loss doctrine applied to bar such claims against design professionals who have provided professional services in the commercial property development or improvement process. Formerly, once a builder had completed a structure and the purchaser had accepted it, the builder was not liable to a third party for damages suffered because of the work's condition, even if the builder was negligent. The purchaser had remedies against the builder in contract and warranty. Injured third parties had no clear remedy until the Supreme Court of the United States, following the trend that began with McPherson versus Buick Motor Company in 1916, qualified the general rule exonerating manufacturers from third-party claims with an exception applicable whenever the nature of a manufactured thing is such that it is reasonably certain to place life and limb in peril when negligently made, the manufacturer can be found liable. The Supreme Court had already held that the manufacturers of defective ladders, elevators, and tires could be liable to persons not in contractual privity with them, yet foreseeably injured by their products. The Supreme Court had no trouble applying the same rule to someone responsible for a defective railing. Consider Hale v. Powley, a 1948 decision. On the other hand, in Arizona, the Court of Appeal in Karstens v. City of Phoenix, a 2003 decision, refused to allow plaintiffs to sue the building inspectors for negligence because there was no bodily injury or property damage suffered. The Court of Appeal justified its holding by expounding on the history of the legal theories requiring actual damage. In Arizona, it is well established that a homeowner may not recover in tort against a contractor for economic losses attributable to defective construction when the negligence has not caused personal injury or damage to property other than the defective structure itself. The Arizona Supreme Court first recognized the applicability of the economic loss rule in construction defect litigation in 1984 in a case called Woodward versus Churco Construction. In Woodward, homeowners sued the builder of their house for both breach of implied warranty of workmanlike performance and habitability, and negligence after large cracks developed in the house walls and foundation. The fireplace separated from the wall. A family room wall shifted forward. The kitchen ceiling began to bow, and the floor warped. On appeal, the court affirmed the dismissal of the negligence claim, but reversed the court's ruling on the implied warranty claim because the 6-year statute of limitations on that claim had not expired. A plumbing contractor had a general duty under tort law, separate from any contractually assumed obligation, to exercise reasonable care in any work undertaken, including taking precautions to avoid dangerous gas explosions. In a California case, a contractor who was renovating the insured's bathroom accidentally drove a nail through a pipe while hanging new drywall. The nail caused no leak at the time and went unnoticed until years later, when corrosion around the nail caused a leak, as well as extensive water and mold damage. The insurer denied coverage on the ground that damage arising from third-party negligence was excluded whenever it interacted with an excluded peril, including corrosion or leakage of water. The insureds filed suit, arguing that the contractor's negligence in driving the nail through the pipe was a covered peril and was the efficient proximate cause of their loss. Under the efficient proximate cause doctrine, when a loss is caused by a combination of covered and excluded risks, the loss is covered if the covered risk was the effective, efficient, proximate cause of the loss. On appeal, the court noted that the efficient proximate cause doctrine was superseded by the California Supreme Court's analysis in Julian versus Hartford Underwriters, a 2005 decision. In Julian, the court held that an insurer is not prohibited from drafting and enforcing policy provisions that provide coverage for some but not all manifestations of a particular peril. The court held that the homeowner's policy effectively excluded coverage for consequential damage arising from a contractor's negligence, a covered peril, whenever it interacted with an excluded peril, such as corrosion or water leakage. When a loss is not excluded under the policy, coverage exists under the ensuing loss provision because there is no rule of law excluding coverage under an efficient proximate cause analysis. The insurer is precluded from changing the grounds for its denial of coverage, and there is no basis for a jury to determine the efficient proximate cause of the loss. The dispositive question in analyzing ensuing loss clauses is whether the loss that ensues from the excluded event is covered or excluded. If the ensuing loss is also an excluded peril or an excluded loss under the policy, there is no coverage. But if the policy covers the peril or loss that results from the excluded event, then the ensuing loss clause provides coverage. A contractor can also find himself or herself responsible for a negligent misrepresentation of fact, that is, an assertion of a fact that is not true by one who has no reasonable ground for believing it to be true. Typically, whenever claims of fraud or intentional misrepresentation are pleaded, lesser offenses such as negligent misrepresentation are usually included as one of the many causes of action alleged in a construction defect suit, even when the misrepresentation is only negligent rather than intentional. If the plaintiff honestly relied upon the representation to his detriment, the plaintiff will be entitled to tort damages for the misrepresentation. This video was adapted from my book, Construction Defects and Insurance, Volume 1 of 8 volumes, available as both Kindle books and paperbacks from Amazon.com and from my website, Zalma.com, by clicking on the link to the insurance claims library. If you found this video to be interesting or of use to you or colleagues, please refer it to a colleague. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and blog postings. Thank you for your attention.